All right.
So I think we were talking about November 12th, which apparently is a Portland Tax Forum that conflicts, but would that still work for folks if we moved it to 9:30 start time?
Yeah, it'll be a fantastic day.
Okay. So I'll send out the meeting invite for 9:30 to noon for the 12th.
Perfect.
So are we going to go to 12:30 or just noon? Cut it short a half an hour.
Well, let's see how far we've got. Cindy, let's block out the time till 12:30, but with the goal that we'll try and stop by noon so that people can get some lunch.
Okay.
And then December, what does people's December looks like? I mean, honestly, who knows in this world, right?
Yeah,
exactly.
Yeah, I got no idea.
Well, let's put something on the calendar just so that we can have it there. And then if that doesn't work, it doesn't work. And if the world ends before then
well, Valerie, it is after November 3rd, so the world may end.
Yes, it might.
I'm praying.
That causes some stress at a very visceral level at this point, Jeff. So let's not make jokes.
Oh my God, I am leaving the burners on the stove all the time. Things are boiling over. Like, what's wrong with you? I can't focus on things.
Well, Valerie, the whole point of the jokes is because I am so stressed out. I need some levity, something to.
All right. Well, whatever we can do to help your stress level, Jeff.
Right. Well,
so,
new jokes.
What does December 10th look like?
Looks fine to me.
Yep.
Yeah. I haven't looked at the final exam schedule, but I'm sure it's fine.
So I'm sorry to complicate things, but Thursdays are generally not good for me.
Oh, really? Okay.
Yeah.
What about the 9th?
Yep, I can do that.
Okay.
School's over. Yes.
Kyle, does that work better?
Yep. Okay. Thursday the 9th is fine.
Wednesday the 9th.
Wednesday the 9th.
Wednesday the 9th.
Thursday's what we're avoiding. Thank you.
Yeah, again, stress. You got to think about my stress level.
All right, so I'll get meeting invites out for the slightly modified meeting for November 12th and then also for December 9th.
Yeah, I feel like we should have some sort of like goodbye 2020 party. I feel like the entire month of December should be dedicated to wishing it goodbye.
Really, I agree.
Okay.
I totally agree, but I also feel like we're counting our chickens with that sentiment a little bit.
Oh, mean, Cody. Again, think of my stress level. Okay, so Sandy, could you please get those out by the end of the week?
Absolutely.
I know that people are shockingly busy right now, and so it's good to get these things on people's calendars.
No, agreed. I'll actually take care of it this afternoon.
Okay. 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 So we spent last time mostly talking about, finishing up Article 5 and then talking about the beginning of Article 6, which, has some new concepts, I think, for us in the Oregon LLC world. And so we went through 601, which is the power to dissociate as a member, and when someone can leave the entity. And then 602, which we're going to start today, talks about situations when someone is dissociated as a member. And, and David, feel free to leap in. The closest that I could find in the ORS is at 63209, which talks about expulsion as a member. And that section says that, a person can be expelled from a limited liability company in accordance with the operating agreement's written provisions, or by a court if the court determines that the member has been guilty of wrongful conduct that adversely and materially affects the business or affairs of the limited liability company, or if the member has willfully or persistently committed a material breach of the articles organization or any operating agreement, or otherwise breached any duties to the point where it's not reasonably practicable to carry on the business or affairs of the company with that person remaining as a member. So that's where we're coming from.
So Valerie, there's also another analog, which is ORS 63265, which deals with cessation of membership. It includes death, incompetency, bankruptcy, dissolution, withdrawal, expulsion, or assignment of a member's entire membership interest. So that's about as close as Oregon gets to this concept of of dissociation,
Yeah.
I should say.
Yeah, and I think that's really important to note. So it's 63, 209, 63, 265.
Yes.
So, I think the overarching, it's a long section, 1, 2, 3, 4, 3.5 pages plus several pages of commentary. And I think what they're trying to get to is they're trying to, again, set up the framework for our carpet layers where, in what situations would, a person become dissociated and no longer be able to continue as a member of the entity. So I do think that it adds that the proposed language adds a lot to the current statute, and I thought we could talk through sort of the major parts of it. And so the first section just basically says that the limited liability company knows that the person wants to withdraw as a member, but if they specified a withdrawal date later than the company knew or had notice on that later date. So basically it just ties, I think 601 to 602 and says that, you can agree on a date when someone is going to leave the entity. So I think that's fairly non-controversial. Similar, sorry, go ahead. Did someone say something? Okay.
Well, the only thing I say, it has this goofy language in there. It says of the person's express will to withdraw.
Yeah.
Whatever that means.
That language is from you find it in the Uniform Partnership Statute too. It just means that they've expressed their will to manifest their intent to withdraw.
Yeah.
Okay. Yeah, the commentary doesn't really talk about it at all.
Yeah, so I think that's fairly non-controversial. I mean, it's the situation where people agree that someone is, going to leave the entity. And then the second one is pretty similar to what we've got currently in 63-209, which is something happens in the operating agreement and an event stated in the operating agreement as causing the person's dissociation occurs. So it's a little bit wacky wording. And it's not expulsion in the sense that, it has that negative connotation, but it still is, they do something and the operating agreement says you're out, and so you're out.
So what's the difference between subsection 2 and 4?
Well, I think you could have a different event as set forth expressly in the operating agreement that causes a member to versus, actually taking action to expel a member, which is necessarily provided, which it could also actually be in the operating agreement itself.
Right. Yeah, I mean, I think that the 2 is the less fraught scenario.
Yeah.
So,
maybe like when the person turns age 65 or something like that. That's a terrible example, but that could be.
Hypothetically speaking.
Yes. That's what the buyout is.
Yeah, having known a number of folks who've encountered that particular provision. So I think, Jeff, that's a really good point. I think as between 2 and 4, I think that, there may be additional provisions and connotations associated with expulsion that aren't present in section 2. I think they're both useful, and I think we should keep them both in. So my recommendation would be to keep both of those provisions in. And then section 3 adds language saying that, a person may be disassociated as a member when their entire interest is transferred in a foreclosure sale under section 503F. Which gets back to, we were talking about a couple of times ago, with Teresa, where 503F, which is on page 126, that's a situation in which a court orders foreclosure of a charging lien against a member of a sole member of a limited liability company. So, so I think because section F is relatively new, and we decided to include that, I think it makes sense to include sub 3 rather.
Yeah, and my big issue is, I think if the language is clear, is it's not a charging order, it's a foreclosure charging order, an actual transfer
Exactly.
It's just a charging order and they're collecting distributions. They're not actually foreclosing. But I'm comfortable that that language just covers the foreclosure piece and not the establishment charging order.
Right.
Yeah, I agree with that. And the reference to section 503F is talking about sole members of limited liability companies. So it's fairly limited context in which this happens, the single member LLC.
Yeah, and I think it's useful from a mechanics perspective. I don't know, I mean, conceptually it all seems to work together for me. And we already had the discussion when we had talked about 503F about sort of what that would look like. So I think it's just sort of the logical outcome of what we already talked about. Does anybody have any additional thoughts about that? Okay.
No.
So subsection 5 is a whole new, and this is where a lot of the meat is, a whole new thing. And it talks about someone is dissociated when a person is expelled as a member by the affirmative vote or consent of all the other members if, and this is, I think, where the parallel to, you know, the sort of the concept of 63209 comes in the sense that, you know, you would have, and you may have a provision in the operating agreement that additionally addresses a lot of these situations. But if you look at page 133, it talks about, you know, situations that someone may have engaged in behavior that is so bad that the other people want to get rid of them. But it doesn't require, which section 63209(1) B sub B, which is terrible numbering, says that, you know, you have to, it would have to be in the operating agreement. They'd have to breach the operating agreement, or you know, a court would have to determine that these things have happened. So here, I think the difference between where we have been and where we're going with this is that the members on their own can decide that, you know, these things have occurred and they can vote the person off the island. Is that what you were thinking, David?
Yes, and so according to the commentary, this is supposed to deal with members who, quote, no longer have any skin in the game, as they call it. So it's a way to get them out. So I think it's meant to address that issue. It does.
No, we're talking about, oh yeah, we're talking, yes, you're right. Sorry. Specifically 5B.
Right, exactly, yes.
Yeah.
Oh, you're right. That's one of the
other
ones, but.
Yeah, and you know, the situation, so 5A, let's just start at the top. 5A says, you know, if this thing happens, right? So if it is unlawful to carry on the limited liability company's activities and affairs with the person as a member, you know, then they can vote them off the island. You know, a situation that occurred to me where that might come up is, for example, you have an LLC that's made an S election, and suddenly you have an unpermitted member. Like for example, you can have a corporate member of an LLC, but you can't have you can't have a corporate member of an S corp. You know, so you could vote them off the island in that circumstance. Now, the timing on that I think would be a little bit wacky, because says it is unlawful to carry on. There's not a prospective application. So, you know, but other situations where it comes to light that you may have
and that's not exactly unlawful. It just means the S election isn't effective. So I don't think that's the same thing as saying unlawful, right?
Yeah, I think what they were getting at was more the situation where the LLC is a firearms dealer and one of the owners has suddenly been convicted of a felony and now is going to jeopardize the license of the firearms dealer because they can't have somebody holding a felony be part of their LLC or something.
Yeah, no, that's a good example.
And also, I just note that it seems to me, and I apologize because I'm just reading this now, that in the Oregon statute, it talks about that the court has to decide. And I actually like the greater flexibility of the uniform provision, which doesn't require a court to decide. But I don't know whether the court deciding was something very significant under Oregon law.
Are we concerned that this may lead to additional litigation? I mean, maybe the litigators in the room aren't concerned about that, but because, you know, here you have, I think that there is a court has to make a determination that, you know, if you're outside of the situation, you know, where here we're switching that ability to make that determination to the members. And, you know, thinking of our carpet layers, is this going to result in situations where they're like, well, yeah, of course it would be bad, illegal for us to continue to do this activity, when in fact, maybe it wouldn't be. I mean, would we have a lot more wrongful dissociation cases out of that? And is that something that we should think about?
I personally think it would be rare, but particularly I think if you're involving carpet layers, they probably couldn't afford to hire a lawyer.
But related to that, I note, just going back to the beginning of 5, it says the person is expelled as a member by the affirmative vote or consent.
Yeah.
Of, I take that back, all the other members. So it has to be unanimity.
Yeah.
Well, at least
Right.
this is the default rule.
Right, you could change that.
So I'm wondering about the scenario with a two-member LLC, where one person wants the other person out. They might opportunistically, perhaps wrongfully, exploit this provision to say there's been consent of all the other members that it's unlawful to do business with you, and try to kick that other person out. Now, that would not probably be the appropriate use of this provision, but I worry that this provision could be abused in that way and results in the person who's been kicked out now having to litigate the issue.
Yeah, I mean, I think that's my only concern about this provision. You know, because it's a very serious thing to kick someone out of the entity, right? You know, and the model that ROLCA adopts is not a court supervised model necessarily.
Well, there would be judicial supervision, but only after the
Right.
attempted expulsion.
Well, and as Jeff points out, only in the situation where people can afford counsel to fight it.
But it comes down to the standard is it has to be unlawful.
Right.
And so Teresa gave an example of that. Another one I'm dealing with right now is an OLCC license.
Yeah.
Where one of the people got convicted, and thus that's going to disqualify the entity from the OLCC liquor license.
Right.
So there are, I mean, the standard's kind of, in my mind, clear cut. It has to be unlawful to continue, and losing your firearms license or losing your liquor license, that's unlawful, and there's no dispute there. So it can be abused, but I think the standard is unlawful is somewhat clear.
Yeah, I just, you know, usually we look to courts to determine if things are unlawful. And so that's my only concern with this provision is, you know, I think it makes sense, and I like the flexibility that it adds, because it is expensive to go to court, and there are fairly clear-cut situations, for example, where you say, well, if you have this type of conviction, you can't have a firearms or an LLCC license. But you know, I wonder if well, I guess my concern is just that it's going to lead to more litigation.
But isn't it a question of when the litigation happens, though? Because under the Oregon statute, a court has to determine it first. And here it's, well, maybe a court comes in later, but maybe not.
Yeah.
Well, and you're also assuming that every dissolution under this provision is going to be disputed too. I mean, so take the firearms dealer, and you've got one member of the LLC who was convicted of a felony. He may not oppose it. He may realize that it jeopardizes the firearms license and just want his 20% and go home, or whatever, you know, the deal is to get rid of him. Whereas Oregon statute involves a court whether or not it's disputed. This way, we're only involving courts if it's going to be disputed, and it does affect the timing. It's after the fact, but you know, the courts have enough to do. I would be inclined to only put things that are disputed in front of them.
Well, and that is fair. You know, and I do like, I think your point is well taken, and that it adds that flexibility. So if people are okay with this language, I think we can recommend adoption. I just wanted to raise the issue for discussion.
There's no middle ground, though. I mean, either we have the flexibility and we include it, and it can be abused and end up in court and dispute, or we don't include it. I'm in favor of including it, but I don't see middle ground. You have it or you don't.
I'm in favor of including it as well. So.
Okay.
Me too.
I like the Rolka model as well on this, but I think that, we had put a pin earlier in some of the section 105, what can you vary in your operating agreement with regard to fiduciary duties. And I think, okay, so fine, we're doing expulsion as a post hoc litigation matter, but let's remember that when we're looking at 105 and how much they can waive of the, so because we don't want to take away essentially the ability of the ousted member to challenge their ouster.
I'm just making a note.
I do think that would be inevitable, though, if one member or a couple of members just unilaterally took this action.
Yeah, and there are people who would do that out there. I mean, that's why I just think we need to have the discussion. And it may be that this is not a provision that's particularly controversial because they give a notice of intent to dissociate and then it ends up in front of a court prior to that dissociation, right? So that's possible. But it's going to be an adjustment in how we handle this sort of situation. Sorry, I'm just looking for 105 here so I can make my note on it. It's going to be an adjustment in how we handle the situation going forward.
So to Cody's point, is there, I'm just trying to think of, so Cody, was your point that maybe the drafters of the LLC agreement could say, no, you can't sue if you're,
or essentially they could, they can limit the fiduciary duties and so forth. I mean, under Rolka, they could completely eliminate, any general duty not to do a wrongful dissociation. And theoretically, maybe then the ousted member is left purely with a breach of contract action. You ousted me when you were not contractually authorized to, but there wouldn't be any tort claim, for example, because all those fiduciary duties have been eliminated through the operating agreement.
I took Cody's comment differently, actually, although I think both interpretations are correct. I interpreted it, and this is what I commonly see in LLC agreements, is the LLC agreement will specify these are the only ways a member can be dissociated, and these are the only ways. So it essentially opts out of the default rule that we're talking about right now in this provision, and the statute or the contract itself will say these are the ways dissociation can happen. And so if we preserve the freedom of contract under 105, then this just becomes a default rule that applies to the corporate layers who didn't have a sophisticated LLC agreement in place.
Well, I suspect that Mohsen is right, that there will ultimately be people draft around this as opposed to just rely on the default rule. And the commentary makes it clear that this is just the default rule.
Yeah, and to Cody's point, if we look at page 23, which is section 105, C5 says that the operating agreement may not alter or eliminate the duty of loyalty. And then I think we said, well, and let's consider, it says, or the duty of care except as otherwise provided in sub D. And so I think it would be a breach of your responsibilities pursuant to duty of loyalty to, wrongfully expel someone, right? You can't alter away that duty.
Well, except for as provided in subsection D. Right. Where then when you go to D, that's where we have, or at least my notes have all this highlighting of, are we going to, we were going to, I think, check with somebody was going to check with somebody about what the thoughts were, because I think there was maybe not unanimity among our committee about what to do about subsection D.
Yeah, I think you're right. And with specifically D3D, right?
Yeah, alter, eliminate any other fiduciary duty. Right, but we were also talking about, how does reckless conduct affect the duty of care? Would that be waivable or not? And just D3A, whether the duty of loyalty can be altered or eliminated just outright. We didn't have agreement on. So.
Right. Yeah, so I made a note to when we go back and take another look at that. So I'm going to cross-reference to page 133 here,
Yeah.
just so we can take that into account. But generally, I think I'm okay with this provision.
I'm certainly fine with 602 as drafted.
Yeah. Oh, the whole section?
Yeah, so am I, you know.
I'm fine with all of 602 as, I'll just throw it out. I'm fine with all of Article 6 as drafted, so.
Okay.
You have us on 603 in a minute.
I was going to say, does anybody want to talk about 602? Because we've got another 3 pages of it to go.
Well, that use the whole meeting to cover section 6, so slow down.
Well, I think we should probably briefly review them just to make sure everybody's on the same page. So,
okay. Okay. So subsection B talks, and this is the one that that David was mentioning, that talks about someone needs to have some skin in the game, and it says that that you can vote someone off the island if there's been a transfer of all that person's transferable interest in the company, other than transfer security purposes or charging effect under section 503, which has not been foreclosed. Any discussion there?
no, the only thing I would say is the commentary talks about a planning, exercise that you should consider to avoid I don't entirely understand the commentary, to avoid the application of this section.
Yeah, so the commentary is on page 135, and it talks about this paragraph permits expulsion when a member no longer has any skin in the game. Under this paragraph, unless the operating agreement provides otherwise, a member's transferee can protect itself from the vulnerability of bare naked assignee status by obligating the member transferor to retain a 1% interest to exercise their governance rights, including the right to bring a derivative suit to protect the transferee's interests.
I just want to say this is a very vivid comment. I'm shocked. I think we need to redact some of the skin, bare naked.
Oh, that's true.
Shocking. Scandalous.
Shocking, you're right.
Yeah, I mean, I think it's the idea that, if you're transferring your interest in security, and sorry, Teresa, you may want to chime in too, but, the idea that if you transfer everything, you don't have the ability to defend your rights in the company. I think that's what it's trying to get to.
I think so too.
Yeah, I think that's right. And I'm trying to think of a situation where somebody would want to transfer everything and then still keep a 1% interest just to keep their hand in the game.
And I think the buyer wouldn't want that either. They would
yeah,
want
I can't imagine
right.
Either side would want that, unless what it is something to do with, some kind of a nasty divorce dissolution where they're trying to transfer a bunch to the ex-spouse and one spouse is keeping a hand in the game. But that just sounds disastrous to me.
Well,
so, I mean, I don't even understand the comment why you'd want to do that.
We had a situation recently where divorcing spouses had both personally guaranteed debt. And one spouse was getting the operating entity in the divorce, and so there was some, I mean, they found other assets to even things out, but there was some concern that, one spouse would run the business into the ground, and then, other spouse would be required to make good on their.
Right, but a 1% interest isn't going to stop you from doing that.
Right.
There is another tax scenario, you guys, which
is always a tax scenario.
Well, again, a multi-member LLC is taxed as a partnership. A single-member LLC is entity. I've had situations where we have intentionally had one member keep a 1% interest when they do the transfer, because if you go and transfer 100% and there's remaining just one member, at that point you go from a partnership to a disregarded entity. It's a deemed liquidation of the partnership, so it has tax consequences. So I've actually had situations where we've kept a 1% membership interest because we didn't want to lose the partnership tax status.
Wouldn't the remaining member just do something like form a corporation to be the other 1% owner?
Is complicated. Now you have another tax return. You usually want to do an S selection for that corporation. And so, yeah, that's one way around that, Roberta, but you're adding a lot of complexity. I've just had a couple of situations where we've actually gone to 99.1% because we wanted to move equity, but at the same time, we didn't want to lose the partnership status. And yes, you can use a corporation as a separate entity to create another partner, but it just adds a lot of complexity. And in both cases I can think of, this did involve spouse, and they just didn't want the complexity. But yeah, that's a way around it.
Yeah.
Mm-hmm.
So I mean, I'm good with language in subsection B. Again, I think it reflects a more sophisticated approach than the current model that we have in 63209. We'll pull up 63265 too.
Yeah, this is much better than 265.
Yeah, I think so.
Right.
Because it just gives more clarity, I think, for the carpet layer situation. You know, it's not just that laundry list. I think it's more thoughtful. So, okay. So any more discussion on sub B? Okay, hearing none, I'm going to put a check mark next to it. And then sub C talks about the situation where the person is an entity. So again, person. The company notifies the person that it will be expelled because the person, being the company, the entity, has filed a statement of dissolution and the person has been administratively dissolved. The person's charter, blah, 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 revoked. So basically it doesn't exist anymore. And that's consistent with 63.265 sub 1, where it talks about, you know, the dissolution of an entity being grounds for cessation of their membership. And then, but it adds this other wrinkle that says basically not later than 90 days after the notification, the statement of dissolution or equivalent has not been withdrawn or simply revoked. Person has not been reinstated, blah, blah, blah. So they haven't, so, you know, I think it provides for a situation where you have, for example, administrative dissolution, which happens fairly frequently, and says, oh no, I forgot to file the annual report. And so they go and they file their annual report and they basically cure the situation. But I like how it roadmaps out those different steps.
So keeping one thing from a future thing is I use the quote statement of dissolution, which is a term used in ROLCA, which is not a term used in ORS. And we'll see that in Article 7. There's a number of new statements that are present. So whatever we decide in the long run, you know, we don't really going to have any certificates of dissolution or articles of dissolution if we follow through with ROLCA. So it's just something from a drafting perspective I think we need to keep aware of at some point. Everything.
Are we okay though, because it says statement of dissolution or the equivalent? Do we have something that we consider as the equivalent, or is that something we should put in the commentary that we think whatever it is we have under Oregon law is the equivalent?
So I don't really know the answer to that, you know, but looking at Article 7, there's a whole bunch of things in there now that you can file, which is completely different than what we have now.
Yeah.
And a statement of dissolution is only one of them. It could be a statement of termination. There could be all sorts of other things. So
right.
We could leave that to legislative council.
I was just going to say that. I wonder if we should just flag it for legislative council that they need to harmonize this with whatever the provisions are for administrative dissolution in Oregon when you don't pay your fees, which is the most common reason people get administratively dissolved.
Exactly.
Well, okay. Keep that you could also have LLCs from different states that use different terminology. So you apply to a foreign LLC, whatever the equivalent is in that foreign LLC state.
Yeah, and I that's a good point, Jeff, because you know, we're in a world now where we've got all these different adoptions of different versions of this thing, right?
And in some not.
Yeah. And you know, one of the obnoxious bad behavior things that I saw recently was you know, trying to continue operating in Oregon when they'd been dissolved as in their corporation in their state of organization. You know, because there's not great checks and balances as between that. Now, people should be doing their due diligence, but the carpet layered people don't always do that. So, okay, so I'm okay with C. And I think we do flag that for legislative council just to make sure that they're okay with the language, although I'm sure they'll be more than involved in revising any language they think needs to be revised.
Of course, yes.
Okay, so subsection D is sort of the parallel with C, where the person is an unincorporated entity that's been dissolved and its activities and affairs are being wound up, which is, again, provides grounds for a vote off the island, but doesn't have necessarily the cure opportunity and doesn't need the cure opportunity, because how do you reorganize a unincorporated entity? So I'm fine with the language of D as well. Any discussion? Okay, so we'll just put a check next to that one. And then subsection 6.
Sorry, can I go back to that one? Is there discussion in the commentary about what is meant by unincorporated entity? Because many people would say an LLC is an unincorporated entity.
Oh, interesting.
But I would think that LLCs would be covered by the previous subsection and not this unincorporated entity subsection. So I just wonder if there's any clarity.
There's no real clarity in the commentary, except that for paragraph 6, it says the reference to direct action under section 801B, which is, we're going to talk about 6.
We're not on 6 yet. We're on.
I know, but there's commentary that reflects the quote separate entity close quote nature of the limited liability company.
Yeah, that's true.
Well, and with unincorporated, what about partnerships, limited and general partnerships? I'm thinking.
Right, but that's what Mosen's talking about.
Right. Okay. So not the LLC. It's really the partnerships, and limited partnerships.
Yeah, I mean, basically, we're talking about entities that don't have status, separate status and are registered with a government agency, I think, in the situation. Because I think the whole point of C is that you have an entity that may have an inadvertent termination of activity, and then you have to provide an opportunity to cure, where, if you have, for example, an unincorporated entity, I don't think you have the same process associated with that. You look like you disagree, Mosen.
Well, I mean, I agree with some of what was said and disagree with some of it, but I think the issue is out there still, which is what's covered by C and what's covered by D, and is there a clear delineation between the two so that there's not any confusion or dispute?
Do you have any thoughts about how to correct that ambiguity?
I
mean, we certainly could address it in a comment.
Yeah, I mean, so I think one way to correct it is just to, general partnerships are not formed with the state. And so maybe D could be clarified to say general partnership or other unincorporated entity, clarifying that anything that is formed with the state would really fall under subsection C. So that would include LLCs or limited partnerships or LLPs. I don't know, that might just muck up other things though.
Or alternatively, you could just put something like that in the commentary or add it to the commentary.
Well, yeah. I wonder if, they have the hub and spoke model. I wonder if the hub or whatever defines this term.
Yeah.
I was trying to look that up. I haven't found it yet.
Yeah, I mean, my understanding of the most recent permutations of the hub and spoke idea is that a lot of the concepts that were in the first iterations of the hub have been incorporated into these separate acts. So it's sort of an implicit hub rather than a physical, like a not physical, but a explicit.
So Mosen, is the point you're making that what this is probably referring to is an entity that is not created under state law?
No, I'm referring to an entity that is not created by state action. I mean, I guess maybe there's a distinction. So a general partnership, you don't have to file a formation document to create a general partnership, right? It just exists once there's a status of individuals acting as general partners in a general partnership. Whereas every other kind of limited liability entity, there's some paperwork you have to file, right? Yeah. And that paperwork is what creates the entity, and to end the entity requires, again, some state action to end the entity. Here, so subsection C, I think, is dealing with all those entities that require some kind of state action, some kind of formal filing to create the entity. Whereas subsection D, I think, is really just dealing with general partnerships. I think that's what it's trying to say, but maybe not, because it's saying unincorporated entity. And so when I hear unincorporated entity, what I understand that term to mean in certain contexts is everything but a corporation. So subsection D would cover LLCs, limited partnerships, general partnerships, etc.
And I'd throw a wrinkle in here, our partnership statute, which is based on the revised Uniform Partnership Act, RS 67.050 says a partnership is an entity distinct from its partners. So our own partnership statute recognizes partnerships as an entity, even though they're not filing, as Mosen indicated, anything with the state.
So they would still be covered by this subsection D. General partnerships under Oregon state law would be still covered because they're an unincorporated entity, right? The question I've raised is, are LLCs organized under Oregon state law? Are limited partnerships organized under Oregon state law covered by D or C?
I would think D myself.
So is C only referring to corporations then?
Or I think LLCs as well.
I think it's ambiguous because do corporations file statements of dissolution? Like, is that the title of the document that a corporation would file?
They would file articles of dissolution.
Yeah.
Can we ask Ruth to weigh in here, because I think she's got the most expertise in this area. I can't hear you. You're muted.
Sorry about that. I was just pulling up the forms page. So a corporation would file articles of dissolution, as would an LLC.
Mm-hmm.
If they wish to intentionally dissolve the entity. And then, of course, we've already discussed administrative dissolution, but that's the term that we use on our form.
Mm-hmm.
But remember, forms are not prescribed by Secretary of State. People can and do file on all kinds of entities. And make adjustments to those entities without using our form. So our form, it just has that title on it.
Yeah. And then so partnership type entities though, so a partnership falls apart. Like a general partnership certainly doesn't have to tell you guys anything, right?
Only if they have registered like an assumed business name, because they're not doing business under the real and true names of all of the partners.
Mm-hmm.
So yeah, in that case, it would be the assumed business name that they're filing a dissolution for. They're ending that registration.
Mm-hmm.
And it would only be a GP because you do file articles of dissolution for a limited partnership.
Yes.
Mm-hmm.
So one other dumb question, but where would, like, often for LLCs, a member would be like a revocable trust? Would that be a C or a D type of entity?
I don't think a trust is typically considered an entity under these kinds of statutes. I mean, because title is really vested in the trustee as a fiduciary. So I think that's really a relationship rather than an entity.
Is there any clarity on this point from states that have adopted this provision? Like maybe, for example, Washington, maybe?
So Washington didn't adopt this, so.
So just adding a little bit of evidence to Mosen's interpretation, I noted somewhere else in the commentary, in ROLCA on page 11 of the 248-page PDF, there's a reference to LLCs and other unincorporated entities. So totally consistent with the way Mosen is reading that language. I would point out another difference between C and D. C seems to be getting at foot faults. You've been administratively dissolved because you didn't file your annual report. D talks about actually beginning to wind up.
Yeah.
So maybe an LLC could be covered under both, and it just depends on what facts have happened.
That's a good point.
I guess if somebody wanted to take an action for precautionary purposes, they would just couch it under both C and D if they felt that was appropriate.
I'll just mention briefly that in the hub, the model Article 1, which is the actual hub part, it defines entity to include business corps, nonprofit corps, partnerships, limited partnerships, LLCs, cooperative associations, unincorporated nonprofit associations, statutory business trusts. So like it has this lengthy definition of entity that would include all kinds of unincorporated entities. Yeah, it must be, I guess, what you were just saying. Was it David? You were just saying or was it James talking about this, the winding up factor is maybe
Right.
B to D versus C?
Yeah. And that makes sense to me. And I think it makes sense to adopt both C and D. Just because I think they provide that additional flexibility and address what seems to be different situations to me.
I just Googled unincorporated entity, and I won't go into what Wikipedia says, but it did bring up a concept that we should be cognizant of, which is foreign entities. We can have situations where, like, for example, as a statement here, it says an unincorporated entity will generally be a separate entity for accounting purposes, but may or may not be a separate legal entity. For example, in partnerships in England and Scotland are separate entities for accounting purposes, but while English partnerships are not separate legal entities, in Scotland they are separate legal persons. So the point I'm bringing in here is, let's not forget that you could have a foreign entity owning something.
That's a deep rabbit hole to go down.
Yeah.
But it fills in unincorporated can be a lot. We're thinking U.S. entities. Yeah. We got to be thinking outside the U.S. because we have foreign entities owning interests in U.S. entities. Yeah. And, you know, and Valerie, you know, if the tax code, there's a whole regime for trying to figure out what those things are for tax purposes.
Yeah, well, in the U.S., and then it's completely contradictory in some cases to what it is in other countries. We just ran into this issue with New Zealand and New Zealand structure. So okay.
I think we have to kind of stick with D because we have to think outside of the box, meaning outside of the U.S. and the entities in the U.S. because there's a lot of entities in different countries that, what are they? I mean,
I volunteered to go see them all.
You have already. Volunteering to go back.
Not this year. This year's killing me. Okay. So C and D, we're good with C and D. So I'm going to put a check mark next to them both because I do think it makes sense to have them both. Okay, moving on. So subsection 5 talked about the situations where a person's expelled as a member by affirmative vote or consent of all the members. Subsection 6 talks about the situation where a limited liability company, on an application by the limited liability company or a member in direct action under section 801, the person is expelled by judicial order. So this ties back to more towards the 63-209 scenario. And section 801 is, I think, the member direct action provision. Yes, on page 156. And, you know, where someone is engaging in wrongful conduct that has affected adversely and materially or will affect adversely and materially the company's activities and affairs, you know, which is very similar to the language in 63-209 1BA. Or they've committed willfully or persistently or is committing willfully or persistently a material breach of the operating agreement or duty of obligation under section 409. Or C, has engaged or is engaging in conduct related to the company's activities and affairs, which make it not reasonably practicable to carry on the affairs of with the person as a member. So I think all of those things are very similar to what we currently have in 63-209, and you know, similarly to that provision require a judicial order. So I'm okay with those. Any questions or concerns? Comments? Thoughts? Okay. We are moving faster through this section than I thought we were going to, so that's great. Okay, subsection 7. You know, again, situation where someone may be expelled or may be dissociated as a member, and these are the sort of termination events. So a person is an individual and they die, or in a member managed limited liability company, a guardian or conservator for that individual is appointed, or a court otherwise that the person is incapacitated. So, you know, I think that the subsection 7 is 7A is relatively non-controversial. You know, I think what they're trying to get to with subsection B is that you're no longer managing the entity if you're a member managed entity, which again, our conception of that is changing, right? Because we have this idea of apparent authority. But because you have this other person stepping into the shoes and acting on behalf of the entity in the sense that it's a guardian or conservatorship.
Can I ask, I want to talk about the individual dies though.
Okay.
So what happens?
Why not? It's 2020.
Yeah, it's an individual member who dies. The trust or the will says it goes to the spouse or the kids. So the moment the person dies, there's a disassociation. So what does the estate have? And what gets transferred to the heirs? And when the heirs receive it from the estate, does that membership become reattached and it's a member with voting rights or just economic rights? I'm a little bit concerned about just the death thing because of inheritance.
Well, I mean, 63-265-1 already talks about someone stopping being a member in an LLC by virtue of their death. You know, their death, incompetency, bankruptcy, dissolution, withdrawal, expulsion, or assignment of their whole membership interest. You know, so, but when someone dies, and we don't have the restriction that it needs to be in a member managed entity currently in Oregon law. So that is a wrinkle on what we currently have. But, you know, when someone dies, they become, you know, at least most of our operating agreements will provide that they become their estate becomes an assignee of the economic interests, but doesn't necessarily have the voting rights.
Yeah, we covered that in section 501, which and really 500s, which talks about the effects of transferring the economic rights. And what would happen if someone dies is their economic rights would transfer to the heirs, but the governance rights would not.
Right.
And then at that point, you could determine, the LLC could decide to let the heirs in, or it could decide to just leave them with the economic rights.
Yeah, and that was my mistake in that 7A doesn't specifically talk about being a member managed entity. It just talks about the situation where someone dies.
Yeah.
And I guess you could draft around that because these are the default rules if you want heirs to be automatically members and not have to go through the process of getting admitted by virtue of the other members.
Although I don't know why you would, because even if somebody said today that their heirs are Susie and Henry and you like Susie and Henry, that doesn't mean they aren't going to change their will tomorrow and make it Baxter and you can't stand Baxter and don't want to be in a business with Baxter.
Right. I mean, you can always admit someone later as a full voting member. It's just you don't necessarily want to, you know, be in bed with them from a control.
Well, sometimes in the case of like a family LLC, you don't necessarily the kids voting out the other kid or something like that. I mean, again, to me, it's because in closely held LLCs, you might want it to be automatic. Simply put, you draft around it. You draft around vision and you draft around Article 5.
Yeah, I agree.
So one thing to notice here is that under ORS 63-265, you know, incompetency is a ground for cessation of membership, and incompetency is defined in the in our act. And I didn't see this, but maybe I'm wrong, but there's no definition of incompetency in the ROLCA, and so they're sort of defining what that would be in 7B in this case. So you know, it's a little bit.
I think they're saying a court's going to say that, right?
Right, exactly, yes.
Yeah.
And it, you know, and it's the same thing essentially. Under the current act means the entry of a judgment by a court of competent jurisdiction adjudicating the member incompetent to manage the member's person or estate.
Right. Yeah. Yeah, I mean, I do think that makes sense that, you know, in those situations involving capacity, there has to be some sort of determination of incapacity, right?
Right.
So. Are we done talking about people dying, Jeff?
Oh, yeah.
Okay. Any thoughts about 7B, which the member managed limited liability company and you have a guardian or conservator appointed or someone becomes incapacitated or incapable? Okay, good. Put a check mark next to those. Okay, and then section 8 addresses another situation that sort of parallels 63-265 in that it talks about a member managed limited liability company where the person, the member becomes a debtor in bankruptcy, signs an assignment for the benefit of creditors, or seeks consents to or acquiesces in the appointment of a trustee, receiver, or liquidator of all or substantially all of their property. And again, that's the member managed liability company scenario.
So I have a beef with this provision.
Okay.
And
How very rapper of you, but okay.
yeah, and it's the difference between A and C.
Yeah.
So under Section A, if you become a debtor in bankruptcy, no matter how you become a debtor in bankruptcy, whether you choose to file voluntarily yourself or whether you're thrown in involuntarily into bankruptcy, this provision applies. But C, where it's appointment of a receiver, it only deals with consensual receiverships, where you seek consent to or acquiesce in the appointment. So if somebody adversely throws you into a receivership, which is often how it happens, this provision doesn't apply. And it makes no sense to me to draw that distinction. It's either you're in or you're not in, and it shouldn't make any difference to whether or not you consented or agreed to it. So my recommendation is that we revise subsection to C to say that a trustee, receiver, or liquidator is appointed for the person or all or substantially all of their property.
Interesting.
Because the consensual nature of it should not matter.
But Teresa, I mean, if we read it all together, if you become a debtor in bankruptcy, that's presumably could be non-consensual, right?
Right.
Yeah.
So it looks like you may be saying that there's redundancy or we don't need one of them, but I don't see that there's harm in having both.
No, I agree. It should be both consensual and non-consensual that this applies to. And my beef is that this does not apply to the non-consensual appointment of a receiver or a trustee or a liquidator. And it should.
Oh, so you're saying that you could have an appointment of a trustee not in bankruptcy. Is that what you're saying?
Yes.
Okay.
Typically under Oregon law, it would be a receiver, although I can imagine that under other state law, it could be a trustee in another state.
Teresa, I'll point out that debtor in bankruptcy 102 sub 3 is a defined term, and it's an order under Title 11 of the U.S. Code or a comparable order under federal, state, or foreign law governing insolvency. So that's broader than maybe the common usage would suggest.
Right, and I think that they're just triggering off the order for relief. In a Chapter 11 case, order for relief is what happens when you file a voluntary case the moment you file it, or if you're thrown in involuntarily when the court decides you have to stay in bankruptcy. So that's basically saying under Title 11, once you're a debtor in bankruptcy, that's when this applies, and I'm okay with that. And I'm sure they're picking up things when they're talking about other comparable statutes, stuff like the Canadian CCAA, which is their comparable provision for Chapter 11 for businesses in Canada and other countries. So I'm okay with that. It's the fact that this statute doesn't cover involuntary trusteeships, receiverships, or liquidations that bothers me.
Well, that's actually the question that I'm asking here is when you have an involuntary receivership in a state law proceeding,
right?
Wouldn't that be something that is under this definition of 102.3b?
I don't think so. I wouldn't read it that way.
I'm looking at the comments.
So Teresa, would you be okay if just for adding some language to 8A becomes a debtor in bankruptcy or these other things?
I think the easier way to do it is to change the language in C.
Yeah.
Take out the word seeks, contents to, or acquiescence in.
Change that to become subject to the appointment of a trustee, receiver.
I would start the sentence with a trustee, receiver, or liquidator is appointed.
Passive construction.
Yes. For the person or all or substantially all of their property.
Can I ask just real quick, you know, what about like an involuntary bankruptcy that turns out to have been wrongfully filed? You know,
if someone files a petition and an order for relief is not granted, then it's not considered a bankruptcy under the definition of bankruptcy in ROLCA, because ROLCA spins from the order for relief. So the way an involuntary works is you file a petition against someone, and then they have 30 days to fight it. And often that gets expanded to another 60 days. But they don't always, the person who files the petition against the debtor doesn't always win. And that's what you're talking about the wrongful bankruptcy. And there's all kinds of damages under the involuntary provisions in the bankruptcy code that the petitioners are subject to. But no order for relief is ever entered if the
so they don't become a debtor in bankruptcy until after they lose their fight on the legality of the involuntary bankruptcy.
Right. And that's why the trigger for this is order for relief in the definition of bankruptcy. And that's the right trigger.
And what if they appeal that?
It doesn't matter.
Is there a way to be, I guess I'm curious then, is the rule similar if there was some kind of a involuntary appointment of trustee, receiver, liquidator? Or are they just appointed as of the time they're appointed, and it doesn't matter if that was a wrongful appointment or not? I guess part of me, you're making...
That's a court order that appoints them. And it's not just something you do yourself. In Oregon, you have to get a court order to be put in receivership, even if you're trying to do it yourself. Most often, receiverships under Oregon law are not someone putting themselves in. That's the exception, not the rule. So typically it's someone else throwing you into receivership. And often those are contested. But once you have a court order, you have a court order.
So one thing we could consider doing here to address
the appealability rules are written in Oregon, that's probably not appealable for a while. David, till judgment's entered.
I'm just saying, one of the things we could do to address Teresa's concern is the state of Washington did not adopt ROLCA language, and it adopted a much more expansive definition of what would be bankruptcy, which would include many of the items that you have talked about. They have two different definitions. One is, it's all in 2515-131G, and they have two different ones. One that's effective till January 1st, 2022, and one is effective after January 1st, 2022. In my view, the one after January 1st, 2022 seems better.
Can you tell me that site again? I just want to look at that.
It's 2515-131G.
Here, and I can drop it in the chat.
And there's one that is for effective, and I'm assuming I got printed off the correct ones. I'm always a bit paranoid about that. And then there's two sections. One is effective until January 1, 2022, and one effective after that date.
Let me just suggest that if we're going to go change the definition, let's be careful, because that term is probably used throughout ROLCA. And how does it affect other contexts where that term is used?
Yeah, I don't like what Washington did. I just looked at what they wrote, and I'm looking at the current version that's effective. But what they're basically saying is that if somebody starts a proceeding, whether or not you actually become a debtor, whether or not you actually have a receiver appointed, it starts a clock of 120 days to basically have that proceeding dismissed. It's going to leave a lot of ambiguity and a lot of time. I don't think that's the right way to do this.
So the 120-day period is not in the part of the
other version?
The other version, right?
Yeah, let's see. Yeah, it is.
Both.
Sub G?
Oh, I'm looking at F. Oh, you're right. There's two. Actually, there's two of them.
Yeah, so F I think is
G.
dealing with voluntary
petitions,
and then G is dealing with involuntary.
Right.
And I don't like this limbo that gets created in these deadlines that, you got 120 days to get this thing dismissed, because then you're at the mercy of whether a court's going to act very quickly on something.
Would it make any sense not to include the 120-day?
Yeah, it does. I think it's better to just have a bright line. You're either in a proceeding or you're not in a proceeding. And it shouldn't matter how you get there. But if you're a debtor or you're subject to a receivership, then this applies. And if you're not a debtor and you're not subject to a receivership, then it doesn't apply. It's just going to be a lot cleaner and easier to manage if we all have a bright rule here. And Washington kind of puts you in limbo for 4 months.
Right.
Teresa, can I ask a question?
Yeah.
I totally agree with the result you're advocating. I'm trying to understand why the second piece of the definition of debtor in bankruptcy wouldn't pick up a receiver. Isn't comparable order under state law governing insolvency? Isn't that exactly the receiver order?
Because you can have a receiver for situations involving insolvency, but you can also have a receiver for lots of situations that don't involve insolvency. And so it doesn't pick up the universe of receiverships.
Thank you.
Now, as a practical matter, many receiverships do involve insolvency, but sometimes you'll have receiverships of a solvent company where there's a deadlock and they just need a grown-up to run the company while they figure out how to piece the thing out. And sometimes you'll have a receivership of a solvent company just because the person that owns the company died and somebody's got to run it in the interim, and there isn't anybody else to do it. I mean, I've represented receivers in that circumstance before, where the owner became incapacitated.
And so in those situations, you don't think that LLC should become automatically dissociated as the member of this LLC that we're talking about now?
I think that if somebody is subject to a proceeding, regardless of how they get there, this provision ought to apply. I mean, I like the provision, I like A, I like B, I just think C doesn't go far enough because it should apply whether or not the receivership was voluntary
or
involuntary.
Let's ask the question though. And I don't see the answer in the commentary. Why?
I don't either. Right.
Assessment, Teresa. A is voluntary, involuntary. C is just voluntary. The question would be, why did they do that in ROLCA?
I can't think of any good reason why they would have done that. Like,
None
why
of our
would
bankruptcy
you
lawyers.
want to protect people who are in involuntary receiverships? They're the ones who are most likely to not be doing things the way they should have been doing it in the first place, because someone has convinced a court that you've got to get them kicked out and put a grown-up in charge.
Right.
So why, why protect them?
Well, and another thing too is 90% expert, it's involuntary. These actions 90% of the time are involuntarily done.
Yeah, I think that's true. Michael had a question though.
Well, I guess I'm not 100% convinced that this applies only to voluntary situations, because I'm focusing on the word acquiesces. So if you have a person other than the member petitioning for a receiver, and that person acquiesces in that proceeding, then it goes forward here. It seems to be saying that if there's a dispute over the appointment of a receiver, then this wouldn't come into play. So I think it was completely a voluntary, proactive step that's referred to here. Why would you need the word acquiesces there?
Well, acquiesces could just mean that you defaulted and you didn't show up to oppose it. But I mean, in 100% of the cases where a receiver is appointed, a judge has decided a receiver needs to be appointed, because the only way you can appoint a receiver is to have a judge issue a court order to do it, because a receiver is by definition an agent of a court. And so I don't understand why, in a situation where a judge has decided that this person should no longer be in charge of its company or its assets, because for whatever reason, it's not doing what it's supposed to be doing, whether that's incapacity, whether that's bad conduct, whether that's whatever. It doesn't matter. But if a judge has decided that you need to put another human being or a receiver in charge of things, I don't know why that wouldn't be the same as if you consented to having another person be in charge of things.
Well, but think about that. So the creditor, secured creditor, a bank, files a petition for appointment of a receiver against the creditor. The creditor fights it. The creditor loses. The judge appoints a receiver. Does C apply? The way I read it, the answer is no, it doesn't apply.
And it
Because
should. That's my
Well,
point.
I
If
understand
it-
your argument, but I'm just taking the scenario and I'm saying in that case, it would not apply because they did not seek consent or acquiesce to it. They fought it and they lost. The judge agreed one should be appointed, and yet there's no disassociation under 8A and 8C. And I'm just asking the question. Nobody seems to understand why ROLCA makes the distinction and doesn't cover involuntary, cover that situation I just gave you. I mean, why doesn't it cover that?
And I don't know, but I don't understand why it should make a difference if that same secured creditor, well, it'd have to be an unsecured creditor. Let's assume it's an unsecured creditor. If that unsecured creditor went and started a receivership, this rule doesn't apply. Assuming that the debtor disputed it. If they start a receivership, the rule doesn't apply, but if they start a bankruptcy, the rule does apply. Regardless of whether or not the debtor fought it. If they succeed in starting a receivership, the rule doesn't apply, but if they start a bankruptcy, it does. It makes no sense to me.
Well, and what's interesting here, and this may favor where you're going with this, Teresa, is, we have a new Receivership Act, and more we're seeing is instead of the secured creditors in particular going after bankruptcies, involuntaries, they're going after and using the Receivership Act. So we're seeing more of those.
Yeah, so I think that weighs in favor of the, if you are in a receivership, then you become disassociated.
I think so. And the reason that people are doing that is because, frankly, receiverships, for the most part, are less expensive proceedings than bankruptcies.
Yeah, which makes sense.
That's why they do it. And typically, a bankruptcy court doesn't want to deal with cases where there's no assets for unsecured creditors. They kick those cases out. And receivership is the only practical place you can go. And frankly, that's why you see more and more of them, because secured lenders would rather not do a carve out for unsecured creditors so they could stay in bankruptcy. Instead of paying the tip, they go to state court and force the liquidation of their collateral there.
Mm-hmm.
But for this purpose, it should make no difference how somebody gets to that status. It should only matter that they are in that status, that they're in a receivership or a bankruptcy.
Okay. Does anybody disagree with that?
Jump the chase. I'm in agreement with Teresa. We should cover, I think C should cover voluntary and involuntary.
Right. So the way that we get to that is by making the edit, although I suspect that Legislative Council will correct the passive construction, by saying a trustee, receiver, or liquidator of the person or all, substantially all the person's property is appointed.
Yeah, is appointed for the person or all or substantially all of their property. So there's an of that needs to come out of there too, or a couple of ofs that need to come out. That becomes a debtor is passive, and it's passive for a reason, I think, because they aren't focusing on. Now, an assignment for the benefit of creditors in subparagraph B can only be done voluntarily. So that doesn't bother me that it stays that way.
Right, but I think does this, from your perspective, does this cover the waterfront on options that a court has to address this situation?
Yeah, I think so. Okay. I think so. Because I think, as was pointed out, the definition of bankruptcy covers similar proceedings in other countries and things like CCAA, okay, which is the one we most often see here.
Okay.
I was just double checking on the bankruptcy thing. Yeah. And you're right that the order for relief in an involuntary bankruptcy doesn't come until later. But as I was reading 11 U.S.C. 303, it keeps talking about the debtor in the contested, proceeding, and 11 U.S.C. 101 defines a debtor as a person concerning which a case has been commenced. And when you look at 303, it talks about it tells you an involuntary case is commenced when the petition is filed. So I kind of think that at least there's room for argument, it seems facially, that a person becomes a debtor in bankruptcy when the involuntary petition is filed, regardless of whether an order for relief is entered or not. And if the idea is that you want to limit it in the bankruptcy context to a legitimate involuntary, then maybe it becomes a debtor in a bankruptcy case in which an order for relief is entered.
Yeah, but I think they've already covered that in section 102, subparagraph 3, where they define debtor in bankruptcy as a person that is subject of an order for relief under Title 11.
Oh, okay, cool.
Yeah,
Great.
they've already solved that. I agree with you
Thanks.
there that distinction is different in the bankruptcy code, but
Yeah.
ROLCA already solved that problem.
Thanks.
And I think, I like that this gives us more clarity, for these distressed member situations than we probably have in the current code. Right, because the current code just says someone's going to be ceases to be a member and upon their, bankruptcy, and that's it, right? So
Yeah.
So I think that's good. I think it's additional clarity.
Yeah, and it should cover these other situations, ABCs, even though we very rarely see them here in Oregon, and then receiverships, trustees, and liquidators, which we do see.
So I digress, but the current act has a very expansive definition of bankruptcy.
Right.
At OS 63001, subparagraph 3, which would include a commencement of involuntary bankruptcy case.
Yeah, I think they fixed it and made it better the way they've done it here in ROLCA.
Yeah, and here, but if you look at the definition of bankruptcy at sub F, it currently has the language seeking, consenting to, or acquiescing in the appointment of a trustee, receiver, or liquidator. So it requires that affirmative act, it looks like. But then, and then you get to H and it talks about appointment without the member's consent. So I think we skipped that issue by just getting rid of that language. Yeah. Okay.
Yeah.
Okay, so anything further on sub 8?
This may be a stupid question that maybe Valerie, you already addressed, but why is it only applied to member managed LLCs? Why that distinction?
Oh, I think the commentary actually talks about this in the context of paragraph 7B, because again, there's the limitation so in paragraph 7 it says it does not, because 7 is the situation where you have the guardianship or conservatorship appointed or incapacity, and then it says that it does not apply in manager managed situations because members have really limited rights, but given in non-manager members, so so the stated occurrences don't justify dissociation. And I think that applies as well in the situations where you have someone taking control of the membership interest in the form of a receivership. So I think the parallel is to 7B.
But take the distinction that assume it's manager managed, but not all the members are the managers.
Right.
It would seem that you'd want like the guardianship conservatorship maybe apply to the manager member because they're managing and not to a member who
that's a fair point.
Who's not a manager. So to me, it seems like the distinction is not so much manager managed or member managed, but if it's manager managed, who's the manager and who's not, and why should these apply to people who are not managers?
Well, simply because someone becomes dissociated under this provision doesn't mean they cease being a manager. If we're dealing with a manager managed LLC where a member is also a manager, that member manager may become dissociated pursuant to this provision and continue their status as manager. So that would have to be dealt with either in the operating agreement or elsewhere in the statute, that a member manager of a manager managed LLC, when dissociated, no longer is a manager.
Then I'm not understanding why there should be distinctions between member managed and manager managed in both of these sections. Why wouldn't they apply to both types? Particularly when I look at 8. Why would 8 only apply to a member managed LLC and not apply to any manager managed LLC?
I think what we're trying to avoid is a trustee coming in and starting to vote and take action.
Yeah,
that's really only going to apply with the manager manager.
Well,
if
you just have a passive member, does it solve it?
Well, but the members still vote in a manager managed.
On very limited matters. I guess make the analogy to a shareholder in a corporation. Would it make sense for a shareholder in a corporation to lose their shareholder status when any of these things under 7 or 8 occurs? 7B or 8.
Right.
And I guess I would add, Jeff, that in a member managed situation, this person that's a member possesses management rights and potentially has duties to the LLC that you would not see in a manager managed context. And so again, this is just on the list of things that create the disassociation. So I think the drafters of ROLCA felt that this was an appropriate situation in that specific context.
That's the default rule.
Example, though, you have manager managed LLCs where not all the members are managers.
Sure.
The members who are not managers, to them, it's really the equivalent of being a member managed LLC. But yet, you know, 8 will apply in a manager to those people, but it will in a member managed. So again, I think it comes back to, it seems like it's the distinction from what you're talking about, Michael, between who's a manager and who's not a manager. So I'm not sure it's drawing the line in the right place, I guess I'm saying.
Well, I think there's avenues elsewhere for removal of a manager.
Well, that's a good point.
And typically an operating agreement is going to deal with that issue as well.
Yeah, I mean, I do think that's a good point because, you know, this is really aimed at the situation where this hasn't been addressed in the operating agreement, right?
Exactly.
Let me get to the index. Numbers. Yeah.
This does seem to be an ongoing, you know, distinction in ROLCA for whatever it's worth, because it comes up again in Article 7 to some degree.
Right. Yeah, I'm just wondering. So, you know, 407 talks about the management of the limited liability company at page 97, if we wanted to go into that. But I think Michael, I mean, I think Michael's point is well taken, though.
Oh, I think the answer is on page 99 in paragraph 407C5.
Yeah.
A person need not be a member to be a manager, but the disassociation of a member that is also a manager removes the person as manager.
Oh, that does deal with it.
Yep.
Yeah, that works for me.
Nice find.
Okay.
Does that address your concern, Jeff?
Yeah, it helps, yes.
Glad. Okay, can we move on to section 9? So section 9 talks about the situation in the case of a person that is a testamentary or inter vivos trust or is acting as a member by virtue of being trustee of such trust, which makes sense. The trust's entire transferable interest in the limited liability company is distributed, which makes sense because, again, that's the no skin in the game analysis, right?
Mm-hmm.
Any questions, discussion? All right, moving on. Section 10. In the case of a person that is an estate or acting as member of virtue of being a person representative estate, again, their entire transferable interest is distributed. So it's the same as 9, essentially, just in the case of an estate, not a trust.
Right.
Okay. And then section 11 at the bottom of page 134 talks about, in the case of the person that is not an individual, the existence of the person terminates, which makes sense because they're no longer there. 12, the limited liability company participates in a merger under Article 10, and the company is not the surviving entity, or otherwise, as a result of the merger, the person ceases to be a member. So you can't be a member of something that doesn't exist, which I think is the point of paragraph A there. And then, you know, if it's a split up sort of transaction and you're not a member of the going forward entity, you're a member of some other entity, then I think it would make sense so B makes sense to me too.
So one thing to keep in mind for going forward is that this assumes that we're going to adopt, you know, Article 10, and the same thing with subparagraph 13 and 14 and 15, where we will adopt those sections of articles as well.
Yeah, and should we flag them for discussion if we need to at Article 10?
I think so, yeah. Although that one probably is the least controversial of the ones listed under there.
Yeah.
Careful, David. You just tainted it.
You just
Right.
jinxed it.
Well, they have interest exchange. They have domestication.
Yeah. Yeah. I mean, so Article 10 starts on page 175 for people who want to also put a note. But I'm going to put a note to refer back to 602 sub 12 through 15. Okay. Again, 13, limited liability participates in an interest exchange. And as a result of the exchange, they cease to be a member. 14, there's a conversion under Article 10. 15, limited liability company participates in domestication under Article 10, which I think we'll need to talk about because we don't have
that, right?
Yeah. But we'll talk about that because that is included within the concept of 10. So if we adopt 10, you know, what David's saying is right. We should just automatically adopt all of these, I think.
We should adopt domestication when we get there.
Yeah, I would agree with that. So, okay. So any questions about 12 through 15? Hearing none, I'm going to put a check mark next to it. And then 16, again, you can't be a member of something that doesn't exist. And so the limited liability company dissolves and completes winding up, I think is also fairly non-controversial. So I would recommend adoption. Okay, great.
I'm sorry, that great was premature.
Listen, you're reading my parade.
I'm sorry. Maybe this will be quick, maybe not. There was no, from what I observed, there was no real controversy or discussion regarding 6A or B. And I was just surprised that no one else thought those were a little too open-ended and perhaps invite litigation or abuse. Or put too much power in the hands of circuit court judges.
Well, for one, I think it's consistent with, and basically all of 6, all parts of it are consistent with what's been the law in Oregon for decades already. And I think that there's decently well-developed law just throughout the country sort of explicating what these standards ultimately mean. I think if we adopted different standards, that might create greater uncertainty.
Yeah, I wasn't proposing to adopt different standards. The proposal, if any, would be to just omit this section because we don't want courts empowered in this way. But if others are comfortable and if this is consistent with existing Oregon law, I don't want to object to it.
Yeah, I mean, I see the major use of something like this as, you know, the member has been convicted of embezzlement and the judge is saying, okay, now you don't get to do this anymore. That is a common part of the embezzlement judgments that I've seen. Is a lot of companies that have embezzlements end up in my world in bankruptcy and insolvency proceedings. So I see some of those.
So the situation where I could see this being problematic is you have a member who in good faith disagrees about a certain course of business or course of action, and the other 2 or 3 members are saying, okay, this person is engaging in bad faith conduct that's adversely materially affecting the prosperity of our business and should therefore be expelled by the court under 6A. You know, that doesn't seem like a good grounds for expulsion, but I worry that a court might buy into that argument.
You know, even more controversial is they make that same argument and expel under 5A. 5A is a controversial one because that, in my mind, because that's where members are doing the expulsion.
Right.
Yeah,
Well,
The judge is going to be less likely to do something wacky than the other members are going to be, just because the judge is going to probably not act unless the situation's pretty dire.
Right, and I don't think a legitimate disagreement over, what to do, should the company engage in a particular transaction or not, is going to be wrongful. I've never heard of anyone asserting that, let alone a court ruling in favor with that argument. Combined with the fact that, what is the scenario you postulated? So this one member of the three has sort of veto power because the particular transaction can't be engaged in unless there's unanimous consent, or maybe let's say that one member who's the dissenter is actually the majority decision maker, and in which case, anyway, I don't think that that's a problem.
Okay.
Okay, so anything else on 602? Yeah, we're ahead of where I thought we would be time-wise, so great job. Can I propose that we take a 5-minute break right now and come back at 10:33? Is the only other section in Article 6 that talks about the effect of dissociation. And it says that, and I have a note here too that we were going to talk about 404B on page 91 when we got to this. So let's circle back to that in just a moment. But it says that a person is associated as a member. If a person is associated as a member, their right to participate as a member in the management and conduct of the limited liability company's activities and affairs terminates. That seems fairly straightforward to me. David, what are you doing?
I have to touch my iPad to see things.
Keep your hand very close.
Right.
Okay, so person associated member, so section 1 seems non-controversial to me. Does anybody have any concerns about that?
It doesn't say it, but it's pretty clear it includes voting.
Yeah. Yeah, and just to flag 404B. So 404B on page 91 basically says a person has the right to a distribution before dissolution and winding up of a limited liability company only if the member decides to make an interim distribution and a person's dissociation does not entitle the person to a distribution. Okay, so we had flagged that to talk about in the context of 603. Because that's the provision that talks about sharing in rights to distributions before dissolution. So so you may not be able to force, for example, if you have an asset-rich entity, you may not be able to force a distribution to a dissociated member by, having it by the fact of that dissociation. So I think that's to protect the situation where they would have to otherwise sell assets to get rid of someone. You can make them wait. Okay. Okay, so and then section 2 says the person's duties and obligations under section 409 as a member end with regards to matters arising and events occurring after the person's dissociation. So section 409 again talks about, let me get to it. I just had it flagged. Section 409 is on page
107.
Yeah, 107. Thank you. That's standards of conduct for members and managers. And basically that's you don't have duties towards people before and after. Questions, concerns?
So what's depressing about, if you see the commentary on this, it says disputes involving law firms have generated much of the relevant case law.
Not surprised, but okay. So any other discussion about sub 2? Okay. Sub 3, subject section 504 and article 10. Any transferable interest owned by a person in the person's capacity as a member immediately before the dissociation is owned by the person solely as a transferee. And Yes, so the person is dissociated as a member. Any interest that they own immediately before is owned by the person solely as a transferee. That makes sense to me too. Any concerns about the 504 implications of that, Teresa?
No, I think that makes a lot of sense. I mean, what it's saying is you may not be a member with a right to do anything anymore, but you keep your economic interest, which is what is appropriate.
Yeah.
What if it's worth, there's not really any ORS counterpart to subsection A.
Yeah, I mean, I think my takeaway from 6 in general is that it's sort of a practical gloss over what we already have on how you get people out. And so this section makes sense to me in that context as well. Okay. And then B, I particularly like because it says that a person's association as a member does not discharge that person from any debt, obligation, or other liability to limited liability company or other members which the person incurred while a member. And I think about this in the context of new partnership audit rules, where you may have, for example, a push-out election in place where someone's agreed to accept take the result of a later tax audit. And so this would not relieve them, dissociation would not relieve them of their obligations pursuant to the new audit rules and whatever decisions they'd made with respect to that. Question?
There is one ORS counterpart to this, which is 63-249-5. It's somewhat analogous to 603B.
Let me pull that up.
I don't think it's much different though, so.
Okay.
I was curious for Valerie and David, 63-209 sub 2 doesn't have a counterpart in ROLCA. And I was sort of curious whether I assume we would still agree with the principle of that current Oregon law, but is it just sort of implicit in ROLCA? Would it be worth making it be a comment to our commentary that we that we agree with the current Oregon law there, and it's just implicit in ROLCA? Which essentially says that the LLC powers to expel does not limit the rights of the LLC to recover damages from the person that they're kicking out or get any other remedies. And that in addition, the LLC can offset such damages against any amounts otherwise distributable to the expelled member. And then this, I don't know for sure whether adopting ROLCA eliminates that right of set off, or I don't think it would eliminate the ability to sue them for damages, but potentially maybe eliminates the right of set off. I'm just curious what you guys thought about that.
I actually would like the idea of adding 63-209-2 to this section.
Yeah, I think it would fit.
Of 603. I think that would make sense, and I would be in favor of keeping that statute rather than just putting it in the comments.
Cody, take a look at section 40. I'm on 91, section 404D, second sentence. Which does deal with an offset to distributions.
Right, but I think that they're talking also primarily here about the ability to sue or offset damages against the expelled or dissociated member. It's sort of less about do you have to pay a distribution and more about if you do have to pay a distribution, can you shrink that down by the amount of damages you claim that they caused you, and or can you sue them? I think it's sort of just making it clear that even if you dissociate someone, you can still sue them for whatever harm they've done to the company, and that when you have those damages, you can offset whatever distributions you have to make to them.
Yeah, I think that it's partially covered by 404D, the second sentence, but I agree with Cody. I don't think it entirely covers everything that's in 63-209 too.
Well, I don't, it's not contrary to
right.
you know, 404D, right? If we were to add some additional clarifying language in the context of dissociation, you still have the right of set off and to recover remedies. I mean, I think it works. I think when I was reading sub B, I was thinking in terms of the tax issue, of course, which is what I usually think of, you know, and where it's a situation where you have an existing debt, but I guess what you can say is that you may have a situation which the amount of the debt is not fixed and determinable at the point at which they're dissociated, right?
Yeah, I mean, now that you guys have talked about this 603B and 404D second sentence, I think that together those may well encapsulate both of the sentences that are in ORS 63.
Yeah.
But would it make sense to add a commentary here that
so.
we're intending to preserve existing law under 63209 sub 2?
Yeah,
I think it is covered, but just expressing the intent that there's no subtraction from existing law here, I think would make sense.
I think that makes sense too. So
yeah, I agree. 63. 2 sub B. Oh no, sub 2. Okay. So
okay, cool.
Put a comment in there on that. And that is Article 6.
awesome.
Nice job.
Under 2 hours.
It's amazing for 3 sections. Well, for 2 sections because we did 601 last time. Okay, so moving on to Article 7. You know, Article 7 is, we already have provisions that talk about dissolution in the ORSs. So I think in a lot of ways, it's not as quite as controversial, but I've been wrong before about that. So, so maybe it is controversial. So I think the parallel to 701. 701 talks about events that cause dissolution of the entity. And let me pull up. So we're talking about 63, I think 621, right?
Yes.
Yeah, dissolution. Yeah, 621 and the following provisions are basically our roadmap in the current statute for what happens upon dissolution. The comparable Washington statute is RCW 2515-265. You know, and both Oregon and Washington say, you know, here are the things that will cause a limited liability company to dissolve. So, and I have a note in here that we wanted to talk about 503C. So let's flag that before we move too much farther. 503C is a charging order that talks about upon showing distributions under charging will not pay foreclose. So why did we want to talk about 503C here? Who can seek dissolution? Oh, can enforce dissolution. Okay, so let's keep that in mind, that we have this outstanding question about who can force dissolution when we talk about the events that could lead to dissolution. So sub A says basically the limited liability company is going to be dissolved and everything must be wound up upon the occurrence of the following. So the first, you know, just tracking with what we've been talking about throughout this, if the operating agreement says something causes dissolution, then that's going to cause dissolution. So I'm okay with that one.
Okay, and ORS 63, 621, 1 and 2 basically are the counterparts to that.
Yes, exactly. And then, I mean, so basically the only new section here is sub 3. So section 2 says the affirmative voter of all the consent of all the members, which is 63, 621 sub 3. And then sub 3 says the passage of 90 consecutive days which the company has no members unless before the end of the period. And then sub 4 says a consent to, this parallel sub 4. Consent to admit at least one specified person as a member is given by transferees owning the rights to receive a majority of distributions as transferees at the time the consent is to be effective. So basically the people who have any remaining economic rights can appoint someone to be a member, which we don't have in the current statutes. Really?
We sort of have 621 4 talks about at such time as a limited liability company has no members. That's to me about the closest to this.
Right. Yeah, I agree. But it doesn't have the, and sub B says at least one person becomes a member in accordance with the consent.
Yeah, it doesn't have any of that. This is more expensive.
Yeah. So I think what this does is it's similar to the dissociation stuff, and that it says, okay, you know, if you accidentally have a entity that has no members, but someone has economic rights and wants to keep it going, they can appoint someone. So I think it's a cure provision, which I am generally in favor of, because, you know, this is our carpet layer situation. You know, because the operating agreement could plan around this if you didn't want this to happen. But I think it does provide a nice opportunity for someone to cure a situation where the entity might otherwise be dissolved.
That makes sense to me.
Yeah, I agree.
Right.
Before we move on to page 140, does anybody want to talk about any concerns they have with A1 or 2? I mean, it's current Oregon law, basically.
Right.
Can we go back to section 701 3? I'm a little concerned about that
because of the provisions of HB 2191 that requires us to, under certain circumstances, check with the company to find out who is a member. And if we are required to wait 90 days to find out the answer to that, I'm not sure if that's in harmony with HB 2191.
So I think that's ultimately an issue that we'll need to address as a part of the discussion of Article 7, because there really is nothing in Article 7 that equates to ORS 63.661 through 771, which addresses the shell entity issues. And I think at some point I think that's probably policy that was adopted. And so we'll have to bring that into, at least in my humble opinion, bring that into the discussion and add to Article 7 at some point. I'm not quite sure where, but that is an issue.
Yeah, Ruth, would it be okay if we flagged, as we go through, flag the provisions relating to dissolution and then have a bigger discussion about 2191? Because I think whatever policy direction we go with, or whatever direction we go with on that, we really do want to reflect what the policy is. You know, because that was enacted for a lot of good reasons. Yeah. Okay.
Perfect. Thank you.
Thank you for flagging that for us. So on page 140, subsection 4 of section 701 talks about, on application by a member, a court may dissolve the company on grounds that, you know, the conduct of all or substantially all of the company's activities and affairs is unlawful. Again, I'm not sure what that would look like, but I'd love to read the opinion. Is not reasonably practicable to carry on their activities or affairs in conformity with certificate of organization, or the managers or those in control of the company are acting or will act in a way that is illegal and fraudulent, have acted or acting in a way that is oppressive and is or will be directly harmful to the applicant.
Well, actually, you know, before we move on from what that would look like, you know, it's going to affect a major industry in Oregon, which is that, of course, the production of marijuana is legal under state law and unlawful under federal law.
Yeah.
And I could certainly see someone wanting to make the argument that a marijuana business is unlawful, and therefore under federal law, and therefore, you know, should be dissolved.
Yeah, I mean, I think so the parallel that we have at 63.621 sub 6 is upon entry of a judgment of judicial dissolution. I actually think that's maybe better language just because it doesn't pull in all of this other analysis. You know, because there may be situations where it's appropriate to dissolve an entity. You know, but 63,620, the 63,621 sub 6, you know, does talk, it refers to 63,671, which has the judgment of dissolution language, and it talks about, you know, what are the grounds for dissolution. And I think since we have that already set out, I would be inclined to stick with what we've got. But you know, I think what they're trying to do is, I think they're trying to make this you know, focus on unlawful activity, but there may be other reasons too. So thoughts?
Let me just note that this provision, subsection A4, is one that cannot be varied by the terms of the operating agreement. And so whatever language is in here, we're essentially saying this rule applies to all LLCs, even if the members want to agree otherwise.
Yeah, so you couldn't, for example, have a cannabis business where they said, you know, you obviously this is federally illegal activity, but it's legal under state law.
Well, for example, I would point out that, you know, 4B is similar to ORS 63,661. What is that?
B, right?
Yeah, 1B.
That's the only analog to this section.
Yeah. And I mean, I certainly think that we don't want to protect businesses that are engaging in illegal activity. And so I'm okay with the concept of A, but I do think we have to deal with, because this is Oregon, I think we have to deal with the marijuana industry somehow in this provision if we keep it.
Well, that's why I'm saying that, you know, I think, and I think this gets a little bit to what Ruth was talking about. You know, I think a lot of the policy that the legislature has developed about situations where you can force a court can force a dissolution of an entity is embodied in 661, 661, and there's not really a parallel to that.
Well, I mean, I guess you do sort of have that in, what is this, is 1A C sub 4, where it says the Attorney General has other evidence that shows that the limited liability company was used or organized for an illegal purpose, was used or organized to defraud or deceive a person or governmental agency, or was used or organized to fraudulently conceal any business activity from another person or governmental agency. I mean, I'd like to keep that concept. I think that's important.
What are you referring? What are you reading?
ORS 63,661.
Yeah.
Yeah,
that's what I'm saying is that
C 2(4). Sorry, I missed the Romanet 2 there. Romanet 2 subparagraph 4.
Yeah, I mean, then that's what I'm saying is that I think, you know, if we look at 63,661, I mean, I think a lot of the policy that, you know, for example, the language about shell companies, right, is in 63,661 as a reason for the courts to dissolve a limited liability company. You know, I think a lot of those policy reasons are baked into 63,661, and how we get there is via 63,621 sub 6 that says upon entry of a judgment of judicial dissolution under ORS 63,671.
I'm sorry, what was that reference to sub 6? I'm looking for that.
Oh, so 63,621 is the basic
21
provision.
Okay, thank you.
Teresa, I wonder if your concern about the cannabis industry can just be covered by a comment that indicates that recognizes that those activities are legal under Oregon state law, but at this writing, it may not be legal under federal law, and that's not a grounds for dissolution of basically a state chartered entity in Oregon.
Well, I don't think that we could do that just by comment, though. I mean, I think if we're going to do that, we'd have to say unlawful under Oregon law.
Right.
But that sets up a weird conflicts issue, right? When you have other situations.
Well, yeah. You know, does that go too far to say that?
And it does go too far, because there's plenty of businesses that are illegal under federal law that I would like to be able to be dissolved this way. You know, the ones selling cocaine, for example.
Okay, we got to. Yeah, got Teresa on the other end of it.
For what it's worth, Washington punted entirely and has an equitable standard.
What's the equitable
standard? Isn't selling cocaine also illegal under Oregon law?
Yes,
just wondering. Just wondering for a friend.
Well, we may have aren't magic mushrooms on the ballot this year?
They are, yes.
So that's why my thought when I was going through this is I actually like the model under 63.621.6 and then, you know, tracking that through better than what we've got here, because I think it allows a court to take into account Oregon law and current Oregon law rather than saying, you know, here are these sort of bright line criteria.
Yeah, and I do agree with David's comment that I think for policy reasons, we're going to need to preserve 661.
Yeah.
Or through 671, I think, right?
And through 671. I mean, Valerie, you may have a good point that I think if we're preserving the subsection that you referred to, and then 661 and 671, that may be a good pathway. There's some redrafting to do here, though.
Yeah. Well, and you know, I think we'd have to talk with legislative counsel about what that would look like. But I think, Ruth, that gets to some of the concerns that you had raised. You know, and I mean, we'll have to go back and take a look at 3A more globally. But I think the court order part of it, I think, is pretty well organized under the current ORA statutes. Sorry, I just said ORA statutes, didn't I? Like ATM machine. So any thoughts or concerns about having our current, or talking with legislative counsel about having our current model of 63.661 sub 6 through 671 enacted in lieu of sub 4?
I like that idea.
Okay.
Well, are we talking about all of sub 4 or just sub 4A? Because my understanding is that this discussion has been cabinet to sub 4A.
Well, sub 4B we already have.
Yeah.
Right.
And sub 4C.
Sub 4C is pretty controversial in my world because it's on top of the fiduciary obligations that are already articulated by the statute. It gives members and courts another avenue to intervene in the internal affairs of the business on the basis of oppressive conduct, and there's disagreement about what it means to be oppressive conduct, and so the feeling is that there's more understanding as to what constitutes a breach of fiduciary duty, but this language here adds this additional protection that may be necessary but might just be giving courts carte blanche to intervene when there's a disgruntled LLC member.
And we don't have a current parallel, right? But again, I think, you know, if we're talking about a court ruling on this, you know, then I think if we pull in the current model, then I don't think that we're making a policy decision with respect to that. And so I would just substitute, I would just substitute 6 and the track through the 661.6 through 671 under the current model. And then if they want to make a policy change on, you know, oppressive conduct, they can. But I think that's above our pay grade.
So one other issue too, and James has sort of talked about this, but under the, you know, RCW 2515-274, it allows a manager also to seek judicial dissolution, and for whatever reason they included that. So the question is whether we would want to consider allowing a manager to be a part of that. ORS 63 6.661 doesn't allow a manager to do that. At least I didn't see it. Just the member, and in some circumstances, the company itself.
Yeah, I can't envision a scenario where the manager should have that as a default right.
Yeah, I wonder what the rationale of the state of Washington was for adding that.
I'll just throw out that, you know, we had talked earlier back in section 5 about whether a transferee who had foreclosed a charging order, or even whether a dissociated member who is a transferee by virtue of their dissociation would have the right to seek the dissolution under the section 4 here. And this was something I had mentioned earlier, that when they were revising the LLC Act in 2006, the penultimate draft had given those classes of people the ability to seek dissolution. And I think that that makes a lot of sense to give them that ability under these section 4 clauses, because again, when you're the holder of that charging order, it often is a paper tiger, and when you foreclose, then you really have nothing. Or if you're that dissociated member who's owed, you know, money from the corporation, or I mean from the LLC, you still don't have any ability to force them to do anything. And these are rigorous standards that are set forth in 4, in particular 4C, but 4A through C there. And I think that having the ability for that person who's in that transferee status, I actually think that that's a useful thing, because it can help prevent the ability of, you know, these sort of shell entities, these phantom LLCs, or just the misuse of the LLC to defraud the creditor, whether it be a charging order foreclosure, or whether it's a dissociated member.
I agree with Cody on that. I think that would be useful to have. And I think this situation where somebody's, and whether it's the 4 ABC language or whether it's what's in 6361 to 671, I think we are talking about circumstances where there's bad conduct, there's fraud, there's concealment, and really there's no reason to protect people who are doing things like that. So I agree with Cody that the balance tips that we ought to allow people who are dissociated members or foreclosing on charging orders to be able to at least raise these minimum grounds for dissolving an LLC.
So, I mean, I think what you're talking about, though, is more of an addition to 661, right? To incorporate the provisions of 4C in the context of charging orders. Is that correct?
You're talking about revising ORS 63661 to sort of add ROLCA 7014, you mean?
Yeah, because it talks about the grounds for judicial dissolution.
Uh-huh.
You know, and I think to the extent that we want to keep anything in this, I think it makes more sense that we ask Legislative Council to include that in, because right now, if you look at the structure of 63-661, like A talks about a proceeding by the Attorney General, and B talks about it's not reasonably practical to carry out, and C talks about proceeding to, have it voluntarily dissolved under court supervision. So I think the situation where you have, bad actors, and you want to force the dissolution isn't really contemplated in the current statutes, if that's right. Is that right?
Right. Well, 63-661B is quite similar to 7014B.
Yes.
But you're missing 7014A and C.
Right. And I think that, we get to A, in greater specificity by incorporating 661 through 671. But I think that this idea that the managers are bad actors isn't really addressed in the current model that we have in the ORSs.
Right.
So that
So,
would be new, yes.
so as I understand the concept, it would be to essentially modify 63661 sub, I guess, 1B to incorporate the concepts in 701 4A and C.
Yeah, if we, well, I mean, yes, although I don't know
Since
if
B is already there.
A, I think C particularly.
So
I think A is
I'll
more.
say I don't think I am in favor of expanding, creditors and ex-spouses' rights to get at the entity itself, to dissolve the entity itself. I think the sort of the concept of picking your partner is pretty important. So full stop, that's where I would come out on that. If we're going to go down that road, I would suggest that we limit it to things like illegal conduct and not have more subjective standards like oppressive and harmful, which is what I see in C2.
Mm-hmm. Oh, heck, I gotta get going.
Yeah, I think I agree with James on that. Although I think I would like to keep fraudulent conduct along with illegal conduct. I mean, oppressive, I agree. That's one of those things people are going to fight a lot about, but I think illegal and fraudulent are pretty well defined.
So C1.
And to be clear, I still think they shouldn't have the right at all, but yeah.
Well, and I do think it's a policy question, so I think we flag it as a policy question, right?
Just for the record, I'm in agreement with James on the pick your partner issue. I think going down this road too far would blow a hole in that. And so, I mean, there's some very large issues here that even a subtle change could, I think, really blow a big hole in our act here.
Well, I'm going to abandon this discussion. So if all of you would like to continue it in my absence, feel free to do so. But thank you again.
Why don't we pick it up next time? This would be maybe a good starter issue.
Yeah.
Get us flaming out.
Or you could just figure it out and then I'll come back and it'll all be done.
No.
No? Okay.
You
all
take
right.
off the notes, though.
Yep.
Okay, well, I have notes, and let's think about that issue, because I do think that, we want to reflect what the current policy is too, because we don't want to substitute our judgment for that of the legislature. But so let's think about that. If we want to wrap up now, then we can wrap up now. Otherwise, all of you can continue this fascinating discussion. All right.
All right, I'll see you all on the November 12th at 9:30. I'll send out those calendar invites for that and the December meeting today.
Thank you all. Stay healthy, stay safe. I really appreciate it.
Good luck.
Okay.
Bye.
Bye.
Bye. See everybody later.